Hello and welcome to a new episode of Legal Wrangle on corporate laws. Today, we have selected three important judicial decisions given by the Apex Court, the Delhi High Court and the Competition Commission of India. Let us begin with the first case. In this case, the issue is whether the order of the High Court, to the extent it deprives the competent authority to adjudicate in accordance with the provisions of the Companies Act 2013 in offences involving serious financial frauds or economic misdemeanor, deserves to be stayed.
The appellant's SFIO challenged the interim order passed by the High Court directing the release of respondent number 1, Mr. NEERAJ Singal, in a writ petition. The respondent in a writ petition sought his release from the judicial custody, which was allowed by the High Court, holding that the condition imposed under Section 212 subsection 6 and Section 212 subsection 7 violative of Articles 14 and 21 of the Constitution, thus directed immediate release of the respondent.
The Supreme Court stayed the order of the High Court, however, also held that the interim relief granted to respondent limited to his release on personal bond should remain in force during the pendency of proceedings, subject to the fulfillment of the conditions imposed by the High Court.
The High Court had considered diverse aspects of the provisions of the Companies Act 2013, not only limited to the grant of interim relief, but also would create an impediment for the competent authority under the Act. The constitutional validity of provisions apart from Sections 212 subsection 6 and 212 subsection 7 of the Act ought not to have weight with the High Court for grant of interim relief. The High Court ought to have applied the broad contours required to be kept in mind for grant of bail under Section 439 CRPC. Since respondent has secured his release, the court continues the interim direction given by the High Court to release respondent number 1.
In a nutshell, the Apex Court held that the observations made in order may have far-reaching consequences and deprive the competent authority or the statutory authority to proceed in the matter in accordance with the provisions of the Companies Act 2013 in respect of the investigations and including filing of complaint or police report concerning the offences involving serious financial frauds or economic misdemeanor, and therefore deserves to be stayed. In this case, the issue was whether quotation of identical basic price and net delivered cost by the bidders for tender floated by the OMCs for supply of ethanol can be held as bidding in collusive manner. To eliminate the competition by manipulating the bidding process, let's understand the factual matrix.
Two separate information, one by India Glycols Limited and the other by Eastern India Chemicals Limited, were filed challenging the joint tender floated by public sector oil marketing companies on January 2, 2013 for procurement of ethanol. They alleged that suppliers of ethanol contravened the provisions of Section 3 of Competition Act by bids rigging by quoting an exorbitant price for supply of ethanol to OMCs. The notification dated 2nd January 2013 issued by Ministry of Petroleum Natural Gas made government-owned public sector oil marketing companies invited quotations from alcohol manufacturers or supplier of ethanol through a joint tender issued by BPCL on behalf of all three OMCs. The informant India Glycols Limited alleged that Indian Sugar Mills Association, National Federation of Corporate Sugar Factories Limited and Ethanol Manufacturers Association of India persuaded OMCs to come out with a joint tender for the purpose of procuring ethanol from various suppliers in contravention of the provisions of the Section 3, which would cause appreciable adverse effect on competition within India.
The Commission was of the considered view that the sugar mills who participated in the bidding process in respect of the depots located in UP, Gujarat and Andhra Pradesh in response to the joint tender floated by the OMCs on 2nd January 2013 had colluded in submitting the bids by quoting collusive prices and sharing quantities. Further, the conduct of the ISMA and the EMAI was held to be in violation of the provisions of Section 3 of the Competition Act, as they were providing their platforms to sugar mills in facilitating rigging of tender. Accordingly, sugar mills and the ISMA and the EMAI were directed to cease and desist from indulging in conduct that had been found to be in contravention of the provisions of the Act.
The bidders could not offer a satisfactory explanation as to how they arrived at the same basic price and the net delivered cost. Lack of satisfactory explanation offered by the parties indicate that the bid prices have been quoted in a collusive manner. It remains unexplained as to why none of the bidders quoted a price below Rs 35 per litre. The bidders had contravened the provisions of Section 3, Subsection 3 read by the Section 3, Subsection 1 of the Act by acting in a collusive and the concentrate manner which eliminated the competition.
In a nutshell, the Commission held that the sugar mills who participated in the bidding process in respect of the depots located in UP, Gujarat and Andhra Pradesh in response to the joint tender floated by the OMCs on 2nd January 2013 had colluded in submitting the bids by quoting collusive prices and sharing quantities, and thereby contravened the provisions of Section 3 of the Competition Act. Now let's move on to our last case, which pertains to the Central Vigilance Commission Act 2003. The key issue was whether any kind of information gathered by the CVC from various sources, even if it doesn't make any allegation, can be construed as a complaint as defined under Section 8 of the CVC Act. Let's first understand the factual matrix.
The petitioner Walmart India is a wholly owned subsidiary of Walmart Stores Inc. On October 19, 2015, the Walmart Street Journal carried an article bearing the headline, Walmart Bribery Probe Finds Few Signs of Major Misconduct in Mexico. The article mentioned that the investigators had found evidence of bribery in India, which involved thousands of small payments to low-level local officials to help move goods through customs or obtain real estate permits. Immediately thereafter, the CVC issued summons addressed to Mr. Krish Iyer, President and CEO of Walmart India, and Mr. Rajneesh Kumar, Vice President and Head Corporate Affairs of Walmart India, calling upon them to provide details of the alleged bribery. The Walmart India contended that the newspaper reports referred to in the summons did not provide any details and filed the present writ petition challenging the proceedings being conducted by the CVC.
The petition was allowed by the Delhi High Court, and the inquiry being conducted by the CVC on the basis of the newspaper report was set aside. It was, however, clarified that the central government is not precluded from making a reference on the basis of such information, and the CVC would be required to continue such inquiry on such reference being made.
Once it is established that the bribes were paid, the contention that the inquiry being conducted was arbitrary and unreasonable is unmerited. The expression complaint, as commonly understood, would require a statement indicating a formal allegation to be lodged. A newspaper report cannot be construed as a complaint for the purposes of conducting the inquiry under Section 8, Subsection 1 of the CVC Act. The CVC can cause an investigation to be made against officials belonging to such category of officials specified in Section 8, Subsection 2 of the CVC Act.
In a nutshell, the Delhi High Court held that the newspaper report cannot be construed as a complaint for the purposes of conducting the inquiry under Section 8 of the CVC Act. With this, we wrap up this episode of Legal Wrangle. Keep watching the TIOL tube for more such episodes. You may also send us in your suggestions at editor@tiol.in. Thank you for watching and goodbye.